facts that were in the Ombuds report?
Yes, Counsel, I've derived them from the Ombuds report.
So they begin at page 14 and they go up to page 16 of your report.
Yes.
And it says that they are from the Ombuds report. And I'd like to just mention some of them so that we give some context to your findings for the purposes of the record and for the understanding of everybody who's listening. Some of the facts that you included were that Dr. Manamela admitted that there wasn't an official delegation of authority for her to sign the licenses, but that she did so anyway. That the service level agreements were not in place, and where they were, they did not make it obligatory for provision of adequate amounts of meals to the patients. That Dr. Manamela stated that Precious Angels had experience and expertise, yet this NGO was in the list of the top 5 where 80% of deaths occurred. You also said the environment of the NGOs was described, and you quote, as unstructured, unpredictable, substandard caring. Facilities were overcrowded, restrictive. Some had no sheets, pillows, or blankets on their beds. Patients were kept starving and cold. That it was described as concentration camps by relatives and prison-like conditions. And you referred specifically there to the Collett's family. That the NGOs lacked security and were unsafe. That staff were not trained or qualified. That there was poor quality of care in terms of nutrition, hydration, and medications, resulting in patients wasting away. That the NGOs were not funded in time. That there were no piloting or feasibility assessments prior to placements of the patients, and that there was missing documentation. That the transfer of patients was done in a hurry and executed chaotically, despite widespread warnings and advice. That frail, incapacitated, and disabled patients were transported in inappropriate and inhumane modes of transport. That some NGOs chose patients like an auction cattle market. That some were transferred several times, further exacerbating their anxiety and instability. That the patient's conditions were not recorded during transportation, and after the deaths, many relatives were not informed. So those are some of the facts upon which you base your opinion in relation to Dr. Manamela. Those circumstances, of course, are relevant to other officials, isn't that so?
Absolutely.
Can you tell us, in respect of Dr. Manamela, what your finding was?
So when I looked at the facts against the oaths that she'd taken, you know, despite pledging herself to the service of humanity, despite pledging to practice her profession with conscience and with dignity, and despite pledging that the health of her patients would be her first consideration, and despite pledging to respect the life of the patients, she'd actually violated all these pledges. And when you look at the foundational core values in healthcare, compassion, caring, respect, she'd actually went against all these. For me, in my opinion, it was as if these did not exist for her. And if she'd taken oaths, she basically paid lip service to her oaths. I think it's very important to remember that when we have patients, in all situations, Patients must be nursed in facilities that are appropriate, they are appropriately equipped and appropriately staffed. So, and if this is satisfied, it will allow for ongoing observations. And if it's appropriately staffed, where the observations can be interpreted, then this would allow for ongoing care. These patients were denied that. It's also very, very important to ensure that when you want to have continuity of care, it's absolutely imperative to have immaculate record keeping in the healthcare context. And if there's going to be transport of patients, patients must be transported with comprehensive records, and none of this happened in this situation. And it's very, very sad that none of this happened in this situation, because it brings back memories and it calls to mind the situation of Steve Biko. You know, when you look at the conditions at the NGOs as described by families and as described in the Ombuds report, the inhumane conditions, there was starvation, dehydration, almost as if in concentration camps, when one family member managed to get into an NGO, found that there were mattresses without sheets or pillows. And you look at the situation of Steve Biko. He was arrested around August 1977. And when you look at his situation in his cell where he was arrested, he was left lying on a mat, soaked in urine on a cement floor. He was later transported to Pretoria, and he was transported at the back of a Land Rover. And he was transported comatose, in handcuffs, lying on mats at the back of the Land Rover. Here are our patients, okay? Look at the mode of transport. And look at how they were transported. They were actually tied, because there were no wheelchairs, so they were tied to or strapped to the vehicles, the bakkies or whatever they'd used. And we may have forgotten the situation when it came to Steve Biko, but upon reading this, it brought back those reminders.
Of course, it doesn't matter that not all of the patients were transported in that way. Or does it make a difference?
Even if one patient was transported in that way, it's a crime against humanity. It's a crime against that patient.
Are you saying that we should have learned from our history? Can you explain more about your reference to Steve Biko?
I think within our country, and with 1994, okay, not far behind us, this is still fresh in our minds. And it's so important for healthcare workers to ask ourselves, what is it? What happened pre-1994? And what should we do to avoid a recurrence? And certainly in this situation, there was no reflection on that. or at least in my opinion, there was no reflection on that.
Well, what would you say to the view, the fact that Dr. Manamela was not acting in a capacity as a nurse at this time?
She was still a healthcare worker, whether as an administrator or a policy maker, because the code would still apply to her. And it's made very clear in the South African Nursing Code, you can look it up, it's page 5, I think, of the code, that the code will apply to nurses whether directly or indirectly involved in patient care. And as an administrator or at the level of management, she was indirectly involved in patient care. So she took decisions that impacted on patients.
So if a health professional moves, you know, in a health profession's career trajectory, moves from being a practicing professional to a government position, but within health, it is your view that the code, the ethical code, binds them equally when they are working in a different capacity?
Yes, that is my view. And just to add further, because they've all taken pledges, should they determine to move away of their from their pledges, they would need to make open declarations that the pledges no longer apply to them.
So that is a requirement, that's your way out of the oath that you've taken?
So it's not a requirement, but it is the ethically correct thing to do.
Yesterday and today...
Of course, what, sorry, Counsel, what distinguishes this must surely be that the nurse acting in an executive position was making decisions about the nursing requirements of other people. If the decisions were about HR or about renovations of an office building, then the code would not come into
it
play,
would be,
would it?
Justice, it would be specific to the practice of healthcare.
Sure. So that's the limiting thing, that it, executive moved away, would there'll have to be that nexus, that connection with the duty of care, the duty to prevent harm, the duty to heal. Yeah.
But if I may continue, Justice, if the executive was making decisions about HR and about renovations of a building that had an implication on healthcare practice, then that executive would be bound by the code.
Yeah.
In this case, Dr. Manamela and others were having to act in a context where their seniors had already made a decision to terminate the contract with Life Esidimeni. What would you say to the argument that Dr. Manamela had no choice? The contract had been terminated.
I do not believe that she had no choice, despite the contract being terminated. I believe that it would have been important for her to go back to her codes and her pledge, and to abide by the codes and the pledge that she took.
Yesterday and today, we've heard testimony from Ms. Hanna Jacobus, who is also a psychiatric nurse registered with the Nursing Council. And she admitted that she was responsible for preparing the NGO licenses for Dr. Manamela. What would that conduct mean? Would that mean that she too violated her codes? Would this apply equally to others like Ms. Jacobus?
Yes, Counsel. Any nurse that was involved in the project that resulted in wrongs and harms to the patients would be implicated.
Ms. Jacobus, similar to Dr. Manamela, contends that she was following instructions.
So, Counsel, she was following instructions to do wrong. And it's very clear, both ethically and legally, that one is not excused when one does wrong.
In your report, you refer to the concept of dual loyalty. Is that what was at issue here? Is that the conflict that was posed for these officials?
Yes, this was a situation in which a dual loyalty conflict arose. And a dual loyalty conflict arises when there's a simultaneous obligation to patients and to a third party. And in many situations, the third party would be the state. Okay. And what the situation would result in some form of moral distress for the healthcare practitioner, because the healthcare practitioner would be pressurized by the state to follow instructions. However, what should be first and foremost in the mind of the healthcare practitioner is that the patient or patients must be treated as patients. You cannot run away from the fact that patients are patients, and they have to be treated as such.
And that conflict is foreshadowed in the oaths, isn't it so? If you can look at the Hippocratic Oath or the International Nurses Code, the conflict between state power from the state or wherever else and the health practitioner is foreshadowed.
Yes, Justice, it definitely is foreshadowed. Going back 2,500 years in terms of the Hippocratic Oath.
Yes.
And sorry, Justice.
No, not at all. I just wanted to reflect on it again. The facts here surprised me in many ways, in the sense that practitioners, Dr. Silibano, Dr. Manamela, who's a psychiatric nurse, the nurse was here this morning. Strangely, they thought they were bound by orders which were inconsistent with their ethical obligations, professional ethical obligations. Do you want to express yourself on that? Because when you look at the codes, it's always anticipated. Interest of the patients first, and I won't be persuaded by considerations of politics, of religion, of color, of gender, of sexual orientation, and most of these are listed as grounds which should never intrude into professional ethics. But they all, three of them at least, those that I've given you, consistently said they thought they were bound by their orders.
Justice, I think it's important to understand that ethics rises above any orders that put you in a situation to do wrong. And your ethical principles must actually rise to the fore. But it's not only our ethical principles. We look at our constitution of the country and the importance to respect the human dignity of our patients. That's not negotiable. Whether there's an order or not, that is non-negotiable. And so they were also bound by the constitution of the country. And this comes out clearly in the South African Nursing Code and the Health Professions Council guidelines, that while we have our guidelines and codes, we are still bound by the constitution and the laws of the land.
You see, Professor, when forgetting ethical codes, professional ethical codes for a moment, the situation is not different either in law, is it? I know you're not testifying as a lawyer, but I'm taking it back, and common sense, for that matter, let's forget about law. As far back as Nuremberg trials, and even much earlier, people say I was acting under orders. And the first inquiry must surely be, was it a lawful order? But I didn't hear that come through with senior executives here. I'm including those who are non-healthcare professionals and healthcare professionals. It doesn't seem to be ingrained at all in healthcare givers or in the public service that it's not sufficient for political influence or sufficient for administrative seniority or any of all those considerations. When you give, the first question must be, is this a lawful order? Am I asked to do something lawful?
Yes, Justice, I agree with you, because had they sat back and thought about it, and I'm sure they did, they ought to have realized that the order was unlawful. And that, reflecting in itself, could have or should have urged them to think and act differently. And there could have been a concerted effort to actually bring the issues or take the issues out of that executive level that had actually been pressurizing them. They were within their rights to do so. My concern as I read the Ombuds report was it because they themselves lacked compassion? And was it because they themselves just didn't care?
You're saying if they had reflected, then the obvious course would have been to refuse to obey the instruction.
Yes, Councillor, if they had reflected and understood their calling, okay, as healthcare professionals, and reflected on the oaths that they'd taken and the codes that they were bound by, if they'd understood that, they would have not proceeded with the wrongs that they'd done.
Prop, would you say that this is analogous to the situation that public health professionals were placed in during HIV denialism?
It is similar, And again, they were forced to follow orders by senior management. And there were public health officials that spoke out against this and worked with other bodies towards ensuring that at the end of the day, the best interests of the patients were first and foremost.
So we, in fact, very fresh in our memory still is that episode. So we've been here before.
Yes, we've been here several times. Steve Biko, and also if we look at what came out of the TRC hearings in terms of the healthcare sector. So we've been here many times pre-94. And we're here again post-94, and not for the first time post-94.
So the bottom line for you is that conflict would be presented, but the conflict for the health professional should be resolved in favor, or should be resolved by foregrounding their ethical obligation.
I agree, Councillor.
Even if it means going against a senior official.
I agree with you.
Even if it threatens their employment.
I think that would be very important as well.
In this hearing, we've been informed that the Gauteng Department of Health had not reported the officials to the professional bodies yet, because they didn't. Let me start at the beginning. Are you aware that in the Ombuds report there was a recommendation that some of the officials should be reported to their professional bodies?
Yes, Councillor, it's in the report.
And if I recall correctly, it was specifically Dr. Selebano and Dr. Manamela who were mentioned in the report. Do you think it should be limited to those officials? Yes.
No, Councillor. I think all healthcare professionals that participated in this project knowingly participated, knowing that what they were doing was wrong, would need to be reported.
And is it correct that the Nursing Council is empowered to take action against registered nurses, even if it hasn't been reported to the Nursing Council? Even if misconduct hasn't been reported? I think it is the requirement. I think it is stipulated in the law. I just want to know what your view is on that.
So, I think one would have to look at.
It's not complaints driven?
Correct. That the Nursing Council could mirror more to investigate a professional.
I think it would be important for the Nursing Council and the Health Professions Council, especially if the mottos are to protect the public, to have already started investigating.
Whilst you're there, can I just canvass another point, which I think Council canvassed at the beginning? I just want to go back to it. Is there a duty to report unethical, unprofessional conduct that may be inferred from any of the codes? If rights of a patient are violated, or there's cause to believe that they will be violated, in one's presence, in one's knowledge, is there an ethical duty to report?
Within the Health Professions Council guidelines, there is an ethical duty to report. If one finds a colleague practicing wrongfully, then there is this ethical duty to report, especially where lives of patients are put at risk. I'm not totally sure what the situation is with the Nursing Council in terms of their codes.
You see, the profession where I come from and where Advocate Hassan comes from, Advocate Utamo, Advocate Krause, or Grunewald, Advocate Grunewald, the ethical code specifies the duty to report one's colleague on professional conduct. I don't say it happens all the time. I'm really inquiring whether such a duty exists. Because you see here, if somebody like Miss Jacobus was saying she was uncomfortable, she was afraid, she hated what's happening, a call or two, an email to the Nursing Council would resolve that. A report to some professor of psychiatry would resolve that. As she said here, I could think of a million ways in which she could have just let this team. So the question automatically becomes, did she have the duty to report, to disclose, to divulge impending healthcare disaster?
Yes, yes, Justice. She had the duty to ensure that whatever was done for patients was in the best interests of patients. And if she was being pressurized to act in such a way that harmed patients by a colleague, she would have had a duty to report that colleague. It does not have to be spelled out.
So it can be reasonably inferred from, excuse me, from the provisions of the code.
Yes, I agree, it can be inferred.
But the code that applies to medical doctors, it is spelt out in that code, the duty to report.
Yes, Counsel, it's spelled out.
So let's turn then to those codes, unless there's something else you'd like to add at this point on the nursing code and the violation by those nurses who were employed by the department.
No, I don't have anything further.
So you then turned to the codes that govern the medical profession. Could you, like you did with the nursing profession, give us a tight summary of the key aspects of those codes?
Okay, so I've already mentioned the Hippocratic Oath, which is over 2,500 years old. And currently we have a modern day version of the Hippocratic Oath, which is the Declaration of Geneva, an international declaration by the World Medical Association. And that declaration basically informs again on the importance of service to humanity. And it says, you know, the oath, to quote, says, I consecrate myself to service of humanity. And there's a pledge in there to function according to ensuring conscience and dignity, upholding respect for patients, upholding their right to life, respecting their right to life, and doing all in their power to actually promote the well-being of patients. So
While you're on that code, sorry, I don't mean to interrupt you, but one of the aspects of the code that you referred to that also struck me is the following, which is part of the oath that medical professionals are supposed to take. Part of the oath which states, I quote, "I will not permit considerations of age, disease or disability, creed, ethnic origin, gender, nationality, political affiliation, race, sexual orientation, social standing, or any other factor to intervene between my duty and my patient."
Correct. I think that's really important in terms of not discriminating on the basis of disability and not allowing politics to actually influence your duty to your patients.
Are you saying that politics influenced duty to patients in this case?
Well, if you look at the decisions that were taken and who the head was in terms of the situation, the MEC of Health was a political placement. She was not qualified in terms of being a healthcare professional. She had, and I doubt she had any understanding of what true professionalism in healthcare practice actually meant. And if we actually look at the situation, in my opinion, this is definitely a situation where politics, in a very bullied way, determined ethics. And this should never be allowed.
Of course, it will be politics in the narrow sense of the word, isn't it? In the sense that it is a state functionary who is appointed politically. In other words, I'm trying to distinguish between political ideology or sentiment or policy on the one end and the decisions of a state functionary who has acquired the position through a political process. You get the distinction I'm trying to get at, Professor?
I think I understand your distinction, but whether politics in a narrow or broad process shouldn't matter, because politics should not influence ethics.
Yes. In other words, those who wield public power, executive power, derived through politics, should not undermine the interest of the patient.
I agree, Justice, and should not conduct oneself with impunity, because this is the situation that we found.
And you say derives from a position acquired not through professional competence, but through a political process.
Yes, agree, Justice.
Please continue, I interrupted you. You were talking about the codes.
Okay, so we have the Declaration of Geneva, and then another code in terms of the World Medical Association codes that I think is important and applies here is the Declaration of Tokyo. And this Declaration of Tokyo is basically guidance to healthcare professionals in situations of torture, inhumane, cruel and degrading situations for patients in prison or in detention. But I think it applies here because when you look at the description by some of the family members where families were not even allowed into some of the NGOs, it would, by inference, one could draw a parallel with patients being kept in prison-like situations. And this particular code reminds the healthcare professional of his or her privilege in being a healthcare professional, and reminds the healthcare professional that his or her duty to the patient is first and foremost, and no higher order should actually come between his duty to the patient and himself. Yeah.
Would the fact that these were mental health care users and therefore had limitations of their autonomy, would that bring it within the realm of this declaration, the Tokyo Declaration?
Not just the fact that they were mental health care patients with limitations on autonomy, but the manner in which they were treated. The inhumane, the cruel, inhumane, degrading manner in which they were treated brings this into the realms of it.
And the Declaration of Tokyo is specific to medical professionals?
Yes, it is specific to medical professionals. So we have those that are important declarations. And then, of course, we have our Health Professions Council guidelines. And I've referred specifically to the booklet 1 in terms of our general ethical guidelines. And again, the guidelines stress the importance of healthcare practitioners remembering that their jobs as healthcare practitioners actually comes from a position of privilege. Okay. It actually outlines 13 duties. And very important in these 13 duties for me is the duty of compassion, which we found lacking here. There are other duties, and I don't think I'll go through them because this would come out in as we continue. But again, what it stresses is the best interests of the patient is important, and the healthcare practitioner must recognize the fact that he or she is in a situation of power and must not abuse the situation of power.
So as a layperson, we often hear this phrase of above all, do no harm. Is that a correct reflection of the ethical value of a health professional?
It is a correct reflection, and it actually comes in from the principle of non-maleficence, okay? Also a principle, a duty within our general ethical guidelines, and very important. First and foremost, consider the best interests of your patients and do not harm your patients.
So in a way, like constitutional lawyers refer to negative and positive obligations, the duty that rests on a health professional is more than to take positive steps to look after the patient, but also to ensure that no harm, that there's no deterioration. Is that a correct understanding?
That is a correct understanding.
And you spoke about the 13 values from the HPCSA code, and you referred to compassion. There are two others I'd like to just point out to you that also struck me. I mean, they, of course, are all important. But the first one is respect for persons. And it says that healthcare practitioners, so you summarize it as saying that healthcare practitioners should respect patients as persons and acknowledge their intrinsic worth, dignity, and sense of value. And, of course, that would include mental health care users, isn't that so?
Yes, agree, Councillor.
And was that at play, adherence to this value, in your view?
No. The manner in which the patients had been treated was totally disrespectful. There was no regard to their dignity, their inherent worth, and their sense of value.
And a further value that struck me was the one of truthfulness, that healthcare practitioners should regard the truth and truthfulness as a basis of trust in their professional relationships with patients. Can you explain that? I found that to be an important value that was stipulated in the code.
A very, very important value, and it's a value that draws from the general ethics in terms of healthcare and healthcare professionalism. And that's because patients are vulnerable. Healthcare practitioners are agents that serve as that gap between science and society. And for them to serve responsibly in terms of bridging that gap, they have to be trusted. And they have to earn that trust as well, which brings in the notion of trustworthiness. And when you look at the situation that unfolded in this tragedy, they lost that trust.
Would you say they lost that trust by the patients?
By the patients, by public, and by society at large. And this tragedy, and the families, and this tragedy has actually left quite a dent in the reputation of healthcare professions and healthcare practice.
You continue with your oaths to set out the different oaths that are taken upon graduation. It's all contained in your report. And is there something specific you'd like to highlight?
No, well, there are 8 medical schools in the country, and there are 8 oaths that are taken. Unfortunately, we don't all take one oath. Okay. However, the oaths are very similar, and the principles all align to respect for patients, promoting the best interests of the patients, respecting the rights of patients. Some of the oaths go as far as pledging towards advocacy for social justice for patients. Other oaths look at ensuring that the professional knowledge that they have is used towards the safety and well-being of the patients.
Those oaths are over and above the Health Profession Council guidelines you referred to.
Yes, Councillor.
Those are binding on health professionals.
These are binding on health professionals, and these are the oaths that they take at graduation as a public declaration that they understand the gravity of their calling. Understand.
You then applied these codes to Dr. Salabano as the HOD, and you came to some findings. Like I did with Dr. Manamela, if I may just point out some of the facts that you relied upon for your analysis. And again, Is it correct that you drew these facts from the Ombuds report?
Yes, that's correct, Councillor.
So for the sake of completeness and context, I won't refer to all of them, but some of the facts upon which you rely. You say that Dr. Salabano described alternative options and a viable option of purchasing Life Esidimeni as money was available for this, and stated that these were, and you quote, put on the table, and that the purchase was stalled, and then that he said that he was sidelined thereafter. He does not state at whose table the option was put and by whom. You then say he was aware that communities had not matured to the extent of deinstitutionalization. He agreed that the project could have been done differently and that leadership got too involved and made the managers commit serious errors in execution. He admitted that families were forgotten in the process. The Ombud found that his evidence was evasive and contradictory and states that following the interview, Dr. Salabano backdated all licenses to 1 April 2016 and did not indicate the date on which he signed them. We've now heard testimony from Dr. Salabano, and he's admitted to all of those facts and more. On the basis of those facts, what was your ethical opinion?
So, based on this, it was clear that Dr. Salabano realized that the entire project was wrong. And despite realizing that the entire project was wrong, he went ahead and signed off for it to be instituted. So he basically promulgated wrong. And the real concerning part is he was well aware that the communities had not matured adequately for the transfers to happen. And yet he went and allowed for the transfers to happen.
But listen to what he puts up as a defense of sorts. He says, I was sitting on top of the pile. Or he says two things. The first, he says, I haven't treated patients for ages. I'm an executive manager. And he says when he executes that role, he's not bound by the code. That's the first point that he makes. The second is he is removed many steps from implementation. No HOD would know the detail. And therefore, he sees no culpability on his part. But the real point is the first one. The ethical question is the first one, which says, what is his position? And given your opinion here, to the extent that he claims that I was an executive like any other, and he thought he was a dangerous doctor now because he hadn't treated patients in a long time. What is your response to that?
The fact that the decisions that he made impacted lives of patients was very important. And he was bound by his codes, whether he was a non-practicing doctor, a non-clinical doctor or not. He was still bound by his codes because the decisions that he took impacted on patients harmfully and wrongfully. So I think that he was just making excuses, in my opinion.
Professor, would that be a liability qua or as a doctor, or liability as an executive? here we're talking ethical considerations, right? So he still was, he says, I've not been a clinician for years, to use his words, and therefore you can't judge me by the code.
I don't think, Justice, that would apply. He would still have to be judged by his codes, despite the fact that he was non-practicing and non-practicing for many years. The fact that he's still registered with Health Professions Council obliges him to have continuing professional development. And it was his responsibility to ensure that he continued with his professional development, especially since science and technology is so rapidly evolving that one cannot rely on the medical knowledge gained many years ago to institute management at a later stage, and therefore the need for continuing professional development for all practitioners involved in healthcare practice.
I follow that. Of course, even assuming he were right, which I don't think he was, prima facie, he would still have the constitutional obligation, which I see is incorporated in many of the oaths which are taken at graduations. I mean, that is supreme, isn't it? He's obliged as an HOD in a health department to ensure access to health care, and where it exists, not to impede it, not to take it away.
I agree with that, Justice. He basically ignored the codes, the laws, and the supreme law of our land, which is our Constitution. He ignored the fact that patients, even mentally ill patients, have constitutional rights.
Sorry, Justice,
I'm done. I was really at a point of assessing Dr. Silibano's conduct against the codes, and that he tried to place himself outside the codes, yes, and therefore whether or not he ought to be judged by the codes or not.
One of the aspects of the codes that we refer to is truthfulness and respect. So in those respects, would it be fair to say, even as a non-practicing clinician, non-practicing doctor, he would have violated the code?
Yes, I agree it would be true to say that. I think we need to look at the code that he took, the oath that he took. And he was at what was then the Medunsa University, and look at what he had actually agreed openly to abide by. He said, I will actively guard against all human rights abuses. And yet, he was party to human rights abuses. He said, I would strive for good relationships with my patients based on respect, communication, and trust. That was thrown out of the window. He said, I will promote ethical standards in community engagement, including, amongst others, service. There were no ethical standards in terms of the engagement with the community of families and with the service provision for these patients.
Another defense that Dr. Silibano put up was that he did not foresee that death would result. What do you say to that?
I have a concern with a statement of that nature, especially when you look at these mentally ill patients. There's a certain standard of care and a certain duty of care required for these patients. And if one is not compliant with this standard, if the quality is thrown out of the window, you don't have to be a rocket scientist to foresee that patients would be wronged and harmed, there would be morbidity and mortality.
So you don't buy the defense, is that what you're saying?
I agree, Councillor, I don't buy it.
And so your bottom line finding in relation to Dr. Salabano is that it didn't matter that he was an executive. He violated his code.
I agree. He violated medical codes, the law, and our constitution.
You go on staying within the medical profession and the codes that apply. You also considered the role of other doctors in this project, and you referred to the death certificates, some of the death certificates, and a report by a journalist that had analyzed some of the death certificates. Just confirm that that is correct. I'm putting it correctly.
That is correct, Councillor.
I'd like to take you to some of those death certificates to understand what your opinion is in relation to violations by other medical professionals in the context of this tragedy. And so I'd like you to take you to parts of the record. There are files in front of you. And if we could begin with file 9. At file 9, if you could look at, is that 2996? Page 2996. Are you there? This is the death certificate for Busisiwe Shabalala. And it states the usual particulars, and it states the cause of death as natural causes. You see that?
Yes.
Then the notice of death. Well, let me ask you this. Is this form filled out by a medical doctor? The death certificate?
This form that's entitled Abridged Death Certificate is
Yes.
issued by Home Affairs.
And what is it based on? What
It's
informs this?
based on the notice of death certificate, which is filled out by the medical doctor.
So the notice of death certificate then is to be found at page 3000.
Yes.
And if we look at the second page, which is 3001, at paragraph, looks like 22.1, it states that I, the undersigned, and that refers to the medical practitioner, certifies that the deceased, to the best of my knowledge and belief, died solely and exclusively due to natural causes. Do you see that?
Yes.
So there are two options. That's the first option. The second is for the medical practitioner to say, I, the undersigned, am not in a position to certify that the deceased died exclusively due to natural causes. So there are two options.
Yes.
And in this form, the first option is selected,
Yes.
meaning that the medical practitioner certifies the death was due solely and exclusively to natural causes.
Yes.
So please turn to page 3003. And this is the page of the notice of death form that provides for recording the cause of death. And can you tell us from your, and in your medical knowledge, what is the cause of death that's recorded in this form?
So the cause of death that's recorded is hypothermia.
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 And what is hypothermia?
It's extreme cold.
And then underneath hypothermia, it's written severe dehydration.
Yes.
And that's, so there were both conditions present.
Well, according to this death certificate, this notice of death, yes, there was severe dehydration and there was hypothermia. But I'd like to, if I may,
Yes.
draw to your attention that one would like to see what the underlying causes for the hypothermia was. And this death certificate does not have all the underlying causes. Yes, severe dehydration may cause hypothermia, but being exposed to the cold may cause hypothermia as well. And just when you look at Part 1, Section 77, Part 1, just A and B have been filled in. And the death certificate needs to be filled in sequentially with the underlying causes of death, culminating in that final cause of death. And those have been left out. And then Part 2, other significant conditions contributing to death but not resulting in the underlying cause of death. This patient was ill. This patient had a problem in terms of mental illness. And we know with mental illness, there are other conditions that a patient would have, and none of this is recorded here. But having said this, with severe dehydration and hypothermia being noted on this notice of death, I find it very difficult to believe that this would be a natural cause.
So you're saying that the form, first of all, is incomplete? Is that right? It
Yes.
hasn't been filled out.
It hasn't been filled out completely, no.
And the conclusion of the medical practitioner, you're saying, doesn't follow from the cause of death?
It doesn't follow. That's in my limited knowledge. I must say I'm not an expert.
Where are we going, Councillor? Just about to ask the question.
So the expert report refers to the obligations that rest on medical professionals, and that there were many medical professionals involved in everything that took place around this tragedy. It didn't end with the death of the patients. It ended with then how they were treated.
I can see 4.7.1, I can see that. But what I'm saying is that we should just keep in mind that this is an expert who is qualified in respect of ethics and ethical conduct.
Yes.
I know the underlying training is quite clear.
Yes.
He's a specialist doctor.
Yes.
But if you've qualified for one clear area, we're always careful not to travel beyond
Sure.
the scope of the qualification as an expert.
Justice, I don't seek to do so.
Yeah.
The purpose of referring to the death certificates was whether these medical professionals carried out or rather adhered to their ethical obligations in the manner in which they conducted their
So you're
their
supporting
functions.
4.7.1?
4.7.1.
Okay.
So, and
That's fine, as long as we don't call for opinions of causes of death and so on.
No. It's simply the following. and that is whether these medical professionals failed the patients in some way.
Fair enough. You get the point, of course, Professor. You said it yourself.
Yes, I
Plainly
think
so. We're not inviting you to give us opinions about obstetrics or about gynecology or about cause of death. You're here to talk about the intersection between ethics and medicine.
yes, I agree, Justice. And I also would like to state that it is important because as I thought about the opinion, the fact that some of the patients who had died were willfully denied post-mortems, denied them that final step in justice. And we're looking for answers, and the families are looking for answers. And I think it's important for us to consider the ethical issues around how the death certificates were filled in.
Yes. I understand that. That I follow, and I think you may express an opinion on that, yes.
So, thank you, Professor. So, in your view, there was a violation. Well, you could express to me what you see as the ethical violation that is exhibited by this death certificate and notice of death form.
So, my concern here is that the records, the underlying causes of death were actually not recorded adequately. And this was an ethical violation.
And what is the consequence of recording well, let's come to it in a moment. I'd like to take you to another exhibit, and that is to be found in file 11. At page 3848. 3848. It's the death certificate of Ms. Maureen Kunjwa. You have it. And it states the cause of death as natural causes.
Natural.
So what follows is the notice of death after the death certificate. And if we look at page 3850, and we look at paragraph 22, the paragraph that we referred to earlier with the previous example, there's an election that is open to the medical practitioner to certify whether the death was due to natural causes. And what is the election made here?
Well, it's left blank. So this is page 3850.
Yes.
Yes.
And the medical practitioner has not filled in whether the patient died of natural or unnatural causes. But we have a death certificate now issued by Home Affairs that actually records natural causes.
So how would the death certificate have record natural causes? Where would that information come from?
I have no idea.
But the ethical violation here is not only the incomplete, unlike the previous example where the causes of death information was incomplete. There's simply no election made by the medical practitioner.
Yeah.
Yes, there is no election made by the medical practitioner.
The cause of death is paragraph 77, page 3852. So there is a cause of death, but despite the cause of death, there isn't an election made.
Yes, there isn't an election made. So the cause of death reads neuroglycopenic brain injury. And the underlying causes read sepsis, epilepsy, and other significant conditions read cerebral palsy.
So this medical practitioner didn't do their job properly.
The form is incompletely filled, so he or she has not done the job properly, because the fact that the certificate, the fact that section 22 is left blank, is not filled in, means that this is an incompletely filled in death certificate.
And if there had been reason to think that it was unnatural death, then the appropriate course would be to have a post-mortem, a medico-legal inquiry.
Yes, in terms of the Medical Healthcare Act, in terms of the Births and Deaths Registration Act, one will fill in natural causes if one is satisfied that the patient died of natural causes. That's the practitioner, the patient's practitioner. If the practitioner has not been involved in the care of the patient and has been called in to certify the patient dead, then that practitioner must do a thorough examination of the patient and only fill in natural causes if satisfied. Where there is any doubt, in other words, if not satisfied, then unnatural causes needs to be filled in, and this must be reported to the police.
So in your view, was justice and ethics at play here in the final stage of Maureen Kunjwa's departure from our earth?
I would believe that there was a grave injustice done in that the medical practitioner did not fill in whether the patient died by natural or unnatural causes. So that was a problem on the part of the medical practitioner. If he or she was unsure, should have followed the law and reported it to the police and filled in unnatural.
Counsel, I'm trying to anticipate your argument ultimately. These are medical practitioners of unknown descriptions. We are not able to identify them. I look at the names and so on. People have filled in names as medical practitioner. We have a few ones which are filled in by nurses.
Yes.
And some by emergency healthcare workers, something like. So I'm trying to anticipate the argument ultimately that you will make, that if it's that the indignity was exacerbated by professional malpractice, in other words, unethical conduct, the bare minimum is to be able to place it at the door of some medical practitioner. Now, the code would apply to those who fall within a limited class. So I'm trying to anticipate how your argument, less about, I buy the opinion that says that we all are entitled to dignity up to, including certifying the cause of our death properly and lawfully and respectfully.
Yes.
Including the option for an autopsy. if the law requires it. I understand that part. What I don't understand is pegging the ethical concerns on faceless doctors, if there are doctors.
So, Justice...
For now, it's an exchange between you and me.
Yes.
We'll get the professor in a moment.
If I could...
I'm raising a legal question to you now.
I understand. If I could explain where I'm going and what the purpose of putting these certificates to the professor is it's not just about the dignity in the final stage. It's also about what the consequences are of the failure. And it's not about putting liability or blame at the door of any particular individual. From these certificates, we can see that they're filled out by medical practitioners, either a doctor or a nurse, a medical practitioner of some sort. That's all within the regulations and fine.
Ex-fac here, on their face.
Exactly. But the consequence of the ethical violation, so it doesn't end at the ethical violation, the consequence is that for these patients, for these deceased rather, we are unable to know what caused their death. There's nothing in evidence, and there could not be, because of the ethical violations that took place. Because had those professionals, whoever they were, abided by their ethical obligations, then perhaps there would be post-mortems, and that would have given us the cause of death. What we have on record are official documents from the Department of Home Affairs that say that these deaths were due to natural causes. And my argument is that we cannot rely on those certificates.
Yeah, sure. It cuts both ways. That's the point I was really making right from the beginning, in this way. If they are doctors, the ethical question arises.
Yes.
If we don't know whether they are doctors, that might be the end of the inquiry. You get my point? In other words, it's about the reliability, the cogency of the documentation before us.
Well, we know that they're doctors because they, apart from the name, their HBCSA code is noted. So if we accept that ex facie, the document, the truthfulness of those registration numbers and so on, then we can
say the code indicates that they are doctors.
That they are doctors.
Prima facie, we can't say more than that, can we?
No. Well, to the extent that we can rely on a notice of death form, that's an official form.
Yeah, that's a mortuary stamp.
So
I hear the point.
It's on page, for example, Justice, I'm not sure which document.
3850 I'm looking at, for instance, for now.
If I may come in, Justice.
Yes, Professor.
3850, look at section 23. And that states Health Professions Council registration number, which is followed by MP with a number, which means medical practitioner.
Yes, I can see that. Thank you for letting me have seen that. Maybe true here. Let's continue. You've heard the initial issue I raised, and so that we can continue to be. I'll look at the rest, and we might. But you continue. I don't think you should stop at this stage. Then we can have a fuller discussion at argument stage. That's why I say I don't know how to anticipate your argument. Because all evidence must always foreshadow what one ultimately is going to argue. Okay.
Justice, I will be relying on the documents as they are, and the ex facie, the document, the truthfulness, the probity of the
if the state
HBCSA.
Says they are not, they can say so. Yeah.
If anyone were to say these were not actually medical practitioners, then yes,
they can controvert that.
They can controvert that.
I hear the argument.
And in the document that we were just looking at for Lucky Jeremiah Modise, I'm not sure whether we got there. We were about to get there. It's just another example of the same point. At file 9, page 2977. But specifically in relation to your concern, Justice, at 2980, there's a stamp by the doctor, Dr. Yako, with his registration number.
Yes. I think you make a fair point. We'll accept until the state tells us otherwise, that their documents are inaccurate,
Yes.
or not to be trusted. Prima facie, there are doctors. I think you may proceed.
Prof,
I don't have file 9, Councillor.
Okay, no, it's fine, because it's just another example of a point we've already made about the incompleteness of the document and the failure to make an election of natural or unnatural causes. But the death certificate records it as natural causes. It's the same point as the previous example.
Okay.
But you and me can make that inference from the evidence. The question is the ethical point that Professor Dai adds value on, which really is, had they acted ethically, in other words, dutifully,
Yes,
we would have had post-mortem reports.
that's correct.
I
And that would have then allowed us
Yeah,
to establish
a
cause.
much fuller inquiry, a proper inquiry,
Indeed.
and for closure purposes.
Absolutely.
Yeah, I hear you.
So one of the issues, Justice, in the hearing has been the problem with the postmortems, 1, and 2, the fact that most of the deaths are recorded as natural,
Yeah,
and hence this exercise.
no, that's fine. Proceed, as long as you don't make Professor Dai a general practitioner.
Professor Dai, do you have file 11 in front of you?
Yes.
Can you turn to page 3790?
I'm on the page, Councillor.
This is a notice of death form for Nswelengwe Michael Mokheti.
Yes.
And in the section of causes of death, can you read the word that's written in as the immediate cause of death?
So it says sepsis with the question mark that follows, so query sepsis. The underlying causes of death have not been filled in. However, part 2, other significant conditions, they filled in dementia. Okay.
So it's sepsis with the question, with the query.
Sepsis with the query.
And then if we look at 3792, the election that has been made is that it was a death due to natural causes.
Yes. So, if I may, I'm not too sure how one could actually come to the conclusion that it was death due to natural causes when there is a query as to what the immediate cause of death would be. So, in other words, this particular practitioner was not satisfied that the cause of death was natural causes, and hence the query sepsis.
Hence the query.
Hence the query.
And the death certificate, which is at 3795,
Reads natural causes.
but in your view, this was not an act of a diligent medical practitioner to fill out the form in this way.
Yes, a diligent medical practitioner, if not totally sure, would not be totally satisfied, and therefore the cause of death would go on as unnatural.
I was going to refer you to one more, but which is the notice of death in relation to Caswell Mosiani. But as I look at it, it is a repetition of a similar point. So I'm not going to take you there. It's another example, Justice, of no election made of whether it's natural or unnatural. For the record, I'd like to say that at page 3499, the death certificate, however, says that it was death due to natural causes.
Yes. I take the point. I think the point is good. I hear it. And I'm just saying that you and we can look at the documents and we can make the inference. It is the ethical implications that arise from there that we find value in Professor Dye's evidence. Yeah.
Absolutely. And my argument will be that what it demonstrates is why we have ethical obligations, why medical professionals, the ethical obligations of medical professionals is so important to the entire system. We're going to move on from medical professionals, Professor Dye, and there's the next part of your report. You deal with obligations of non-healthcare professionals.
In fact, on second thought, I'm sorry to interrupt you that way. It might be even more important when you are cold, stone dead. Then you are totally vulnerable, and truly vulnerable. And that the point we made earlier about legal prescripts to protect. So you probably need the protection most when you are dead, or at least your family would need the protection most in relation to your cost of death, a possible post-mortem, and ultimately, of course, a proper burial.
That is so.
I get the point.
Councillor, if I may just, please.
Yes.
For the justice, yes.
Yeah. So, I think, filling in medical certificates and death certificates, I think it's so important to actually do this scrupulously, truthfully, and responsibly, because the end result in terms of the way the death certificate is filled in has far-reaching implications. And again, I want to go back to history. And I want to go back to Steve Biko. So Steve Biko was taken for interrogation on the 6th of September after being imprisoned. Okay. And the following day, a district surgeon, which is a qualified medical practitioner, was called to examine him because it was stated that he was not cooperating and he was refusing to answer questions. Despite Steve having evidence of trauma, lacerations and bruises, despite Steve having slurred speech and an ataxic gait, okay, which could imply head injury, okay, the medical practitioner filled in the certificate as nothing wrong with the patient. Then let us fast track to our TRC hearings, the health sector hearings, and look at testimony by Dr. Gluckman, the pathologist. And Dr. Gluckman had several examples of medical certificates and death certificates that were incorrectly filled in so as to exonerate the state. Okay. And there were situations of bullet wounds and injury, massive trauma that was not recorded. And this was brought out during our TRC hearings. So this is a lesson that we need to learn as well. We need to go back to history and look at how we have not learned from history. And I think it's important to highlight this, to prevent this from happening again.
I've got it.
Thanks, Justice.
Thank you, Professor. Proceed, Counsel.
Professor Dawe, we're looking at the next part of your report, which was about ethical infringements by non-healthcare professionals. And you specifically looked at the example of the former MEC, Mahlangu, and you referred to the oaths that are taken in that case, not being the professional oath of a medical practitioner, but the oath that is taken by an MEC upon taking office. Can you take us to that aspect of your report and your findings, please?
Okay, so that's in section 5
Yes.
of the report. And basically, the MEC of Health was, when sworn in, she was sworn in terms of Schedule 2, Section 5 of the Constitution. And basically what she swore to was respecting and upholding the Constitution. Okay. And conducting herself with honor and dignity and being true and faithful. Okay. And clearly, with the type of instructions and pressures that she'd meted out, she'd actually failed this oath. She betrayed her constitutional oath.
And on what facts do you base that finding? Or we can go to page 35, if you could just summarize that, the facts that you base your findings on in relation to the former MEC.
So the former MEC was the final decision maker, and she'd issued the instructions, and according to the Ombuds report, there was an environment of fear and pressure from her. And in terms of the Ombuds report, there was this general culture of disempowerment that had been meted out from her office. And it was, my word, in inverted commas. So basically, it would seem that from her office, she'd actually conducted herself such that it was a reign of terror, which is one would draw similarities with in terms of repressive states.
Yeah, but we have to stick to the facts in the Ombuds report, you know, Professor, because MEC is yet to testify. And the report has been admitted, and that is why it is quite safe territory, as in your report, to stay on the facts as tabled by the Ombuds. Principally because the witness is yet to testify, which is on Monday, and therefore findings will still have to be made. The rest of the witnesses have testified, so one can go to the record and look at the facts. But in this case, I think we must stay strictly on what you've recorded in the report, and then followed by your opinion on the facts that are known from the Ombuds report on page 34 and 35. Professor.
In terms of the Ombuds report and the facts that I'd pulled out from the Ombuds report, she is alleged by many to have said that her decision is final and non-negotiable.
Yes.
And that the project had to be done, and that she left no room for engagement. In terms of the Ombuds report, staff members felt powerless and had to deliver to her the outcome of a project that they did not believe in. And in my opinion, the outcome of that project was a cost reduction from 320 rands a day to 112 rands a day. Okay. And in my opinion, what she'd done is she'd reduced the whole situation. She'd moved from humanitarian needs to narrow financial issues. I've done a calculation. When you look at 320 versus 1112, you're looking at 208 rands per patient saving per day. Okay. Now multiply that by the 1,500, okay, and then multiply it by 30, you're looking at close to about 9.5 million rands a month. Okay, and that is why, in my opinion, it was more financial than humanitarian.
Just to clarify, you're saying that the motive that drove her were costs rather than adhering to the oath?
Yes, I agree. There was also the Ikuruleni.
That is oath of office of the MEC.
Oath of office of the MEC.
Yes, because she would not, it can't be argued that she's bound by any of the medical oaths or nursing oaths.
I agree, Justice. It's the oath of the office. When she's sworn into power, she has to take an oath or an affirmation. And that oath or affirmation is outlined in the Constitution.
Yes.
And she abused that. She was also bound by the Ikuruleni oath, which was declared, the Ikuruleni Declaration on Mental Health, April 2012. And this is attached as Appendix 3 to the National Mental Health Policy Framework and Strategic Plan 2013-2020. And there are pertinent aspects of this Ikuruleni Declaration that would apply. And amongst that is that the users of the mental health care services have to be integral to the planning and delivery of mental health services. And the voices of our patients and their families were ignored. They were not integral to the planning and the implementation. And what it also recognized was the importance of the right of all South Africans to the enjoyment of the highest attainable standards of physical and mental health. And in this situation...
Is that in the Ikuruleni Declaration?
In the Ikuruleni Declaration. And in this situation, it must be achieved through increased services for mental health at all levels of the healthcare services. And what she did was she actually issued an order that resulted in decreased services. Okay. And it commits to, amongst other things, equitable, evidence-based interventions. It also goes to further expand on the fact that the users have to not only participate in the planning and implementation, but the monitoring and evaluation.
But why would the Ikuruleni Declaration particularly bind the MEC?
Because it is an attachment, it is an appendix to The Health Policy Framework Strategic Plan, it is a policy, and she would be bound by that policy.
Yeah. I'm asking this in the light of the fact that she's MEC for Gauteng, for the province.
But the Ekurhuleni Declaration applies to the national mental health policy. So it, despite being called Ekurhuleni Declaration, it would apply nationally. National reach.
Okay.
Yes.
Thank you.
So like the Declaration of Tokyo is still applicable to us?
Yes, and the Declaration of Helsinki and of Geneva. Okay. And this declaration also commits to providing physical infrastructure that responds to the needs and human rights of these mentally ill patients. So it does have important implications.
Yes. Of course, the Constitution itself imposes obligations. You have considered that in your report, and particularly the obligations under Chapter 2 of the Constitution, the Bill of Rights. And in your report, you say that the right to health is of special significance. Why do you say that?
The right to health, I think, is necessary for the realization of other rights, because health is a basic need. Why does one require help? One requires help such that one is functional, one is able to make decisions, and one is able then to recognize what the other rights actually are. So it is a basic need required by all human beings.
And you refer to international obligations.
Yes, starting off with the Universal Declaration of Human Rights.
And all of these are binding, as you point out, they are binding on the government of South Africa.
Yes.
And do you say that they are binding on each individual official?
Yes, they would be binding on all the role players involved in this project.
So you then come to the conclusion on this aspect. You say that South Africa has done well in its legislative framework in the protection of the right to health, but that it fails when it comes to implementation. Can you explain why you say this?
We've got the most, I think, some of the best human rights-based laws. And we look at our Constitution, and I would say that I think our Constitution is about one of the best constitutions internationally, human rights-based constitutions. And yet, when it comes to implementation, we have problems. And our rights are not realized. Now, fast track to our situation here, Life Esidimeni. We look at Section 27, the right to access health care. This was denied to our patients. But other rights were denied to patients. The right to dignity, the right to life. Patients died in the process.
And particularly, we're dealing with rights of mental health care users.
Yes.
Is there anything you would like to say about that, about the position of mental health care users within the health system?
I think it's, I think it's important, like I said before. Here we're looking at not just a patient's vulnerability, but additional vulnerability based on the capacity of patients to understand and make decisions. And based on that, there needs to be a positive obligation to ensure that the rights of these patients are actually protected. And it does not remain at just an obligation, but it remains at implementation of protecting these rights.
Thanks, Professor Dai. Would you like to add any concluding remarks before I close leading your evidence?
Yes, I think I would like to go back to the MEC.
Well, we should, as a matter of process, agree whether we're going to have the closing remarks now or after cross-examination.
So it's not closing remarks in total, it's just in relation to this
Relation
report.
to
If there's
evidence
anything
in chief.
I feel in evidence in chief
Yes.
that the professor feels I did not
Very well.
address.
Because you've got a right of re-examination.
Yes, I understand.
So one of the things that concerned me, and this is what I found on the Ombuds report, was that during the interview, she stated that when a policy decision is taken, you don't know how it's going to unfold and what is going to happen, the risks associated with it. So that's a direct quote from the Ombuds report.
She would have been who? Sorry, Professor, I missed that.
The MEC.
Or the MEC.
The
oh, yes.
MEC.
Oh, yes.
Yeah. So my concern is that she undertook a policy intervention without having adequately explored the risks associated with that policy intervention. Now,
Well, the evidence is that all the risks were pointed out to her.
the risks were pointed out to her. She chose to ignore those risks. Okay. However, when you look at the situation in healthcare, and I want to look at the Ekurhuleni Oath. The Ekurhuleni Oath states that interventions must be evidence-based. There was no evidence-based intervention here. Now, by her saying that, well, you don't know the risks associated with it, one then starts thinking of experimentation. And when you look at one of the definitions of an experiment, and I'll quote, and this is from the Oxford Dictionary, it's a course of action tentatively adopted without being sure of its outcome. So, in my opinion, I would liken the project to a massive experiment that included highly vulnerable patients who, because of their vulnerability being exploited, she exploited their vulnerability. They suffered serious harms and wrongs. And the entire project for me, with patients being herded and taken into concentration camps as described by families, for me, it's a distressing reminder of Hitler's Nazi war atrocities, where the vulnerable were considered to be subhuman, of decreased intelligence, of no moral status, and lacking human dignity, and therefore exploitable. So I'd like to say that. I'd also like to say, in terms of my opinion generally, this is a sad reminder of pre-1994, where black people in our country were regarded as subhuman, lacking moral status or not having moral status, and lacking human dignity. So unfortunately, this project is not only a sad reminder of Hitler's war atrocities, but a sad reminder of South Africa pre-94.
Thank you, Professor. As I close, I would just like to say that, for the record, that you have provided your services pro bono, and for that the families are thankful.
Thank you.
Professor Dai, thank you, Council. we're going to do what things that lawyers do. Everything with state lawyers tend to probe and question. And that is what is going to happen now. Advocate Krause.
Thank you, Justice Musineke. Professor, thank you very much for giving evidence and availing yourself to do so. Can I just make this observation? The atrocities that happened here is not about the deaths only. Would you agree with that?
I agree.
It's about the suffering before the deaths. Would you agree with that?
I agree.
And it's also about the people that survive who suffered.
I agree, yes.
And the family members who suffered as a result of what has happened here. Do you agree?
Yes.
The one aspect further, which I would like to term heightened vulnerability, is the fact that these patients were all reliant on state help. They weren't rich people that would have a medical aid and would be able to go to some other place. Would
Yes, I agree with that.
And that would be a heightening of the vulnerability because their choices would be so limited. Would you agree?
Agree, yes.
I won't ask you about informed consent before, because Professor Grobler will still come in and we'll deal with that in his evidence. But could I just ask you, do you know that in 2007, children were moved from Life Esidimeni to an NGO, and some of them died, and they were moved back to Life Esidimeni, and they were dehydrated and malnutrition? Did you know of that?
Yes, I did. I did actually come across that some time ago, yes.
And how would that affect the ethics of the people having lived through that to do this, to endeavor the same exercise at this stage? What would that history mean for you?
It's very similar to the history that I've brought up in terms of Steve Biko and pre-1994. There was historical experience in terms of morbidity and mortality with a move in 2007. And yet, despite this, the decision was taken to repeat the mistake.
Thank you, Professor. I have no further questions for you.
Thank you, Advocate Krause. Advocate Kuchana. Go ahead of Advocate whenever.
No, we have no questions.
You have no questions.
Thank you, Justice.
Yeah.
We have Professor Grobler who deals with the same issues.
Okay.
I think we're going to lead him, so we have no questions. We understand.
You shouldn't have. You had very many questions yesterday.
Yeah.
And Advocate Quinnaval.
Thank you, Justice. Professor, we only have a few questions. To the earlier witness that testified, Mrs. Jacobus, I put it to her that there was a lack of moral and ethical consciousness within the department. And she confirmed that to be the truth. She said, yes, that is so. Now, something that stood out for me during these proceedings was the fact that those responsible who came and testified, all of them said, well, we could not have foreseen the deaths, and we could not have foreseen that this would happen and that would happen. Now, we know the facts. I mean, we've heard the facts that's been presented. And I mean, it's been the opinion that, you know, they should have foreseen it. Is that a cause for stress to the effect that the department there's a lack of ethical consciousness according to you as well? Can you confirm that from what you've heard and what you've read, that there is a lack of ethical consciousness within the department?
I do agree that it would seem as if the department was devoid of any ethical consciousness, any moral consciousness either. And whatever the department might have had in terms of the patients' rights charters, etc., displaying all over the walls, was just lip service to documents.
I understand the proposition, but I presume you're limiting it to this project.
To this project?
I think it must be made clear. You can't have tie everything around the department. It must be about this project.
This project. This project. Indeed so, Justin. But that brings me then to my next question. I mean, to enforce compliance with the law, that's quite easy. You threaten people that you're going to throw them in jail. But ethical compliance, as I understand it, is a bit higher than legal compliance. That's my understanding. You might be compliant with the law, but your conduct might, can still be unethical. So how do we instill ethical compliance?
How do we instill ethical compliance?
Yeah.
I think we have to go back to the drawing board in terms of the training that our practitioners get, the understanding of what the ethical principles and codes actually mean, and also to try to separate that from behavioral issues as well. Enforcing ethical compliance, I would assume that was the reason. One could have foreseen the difficulties with enforcing ethical compliance, and therefore professionalism in healthcare is highly regulated. And this is where our regulators come in, like the Nursing Council and the Health Professions Council.
Again,
they are there to enforce ethical compliance.
Sorry, Professor. Again, I presume the question is within the context of the project, marathon project. Let's keep it tight. We can't talk about generally how do you enforce ethical behavior.
Indeed, sir, Justice.
There'll be many broken noses which shouldn't be broken.
Yeah.
If we throw it wide, unduly wide.
We've learned from Mrs. Jacobus that subsequent to this tragedy, the department hasn't done anything to explore or to sensitize or to educate or to the personnel in respect of the ethical compliance and so on. So that's basically just my question. How do you go about?
Yes, I just want to make sure the professor understands you're talking about Project Marathon.
Indeed, sir, Justin.
Okay. It must always be limited to that because that's what we are about.
Yeah.
That's all I'm saying.
No, definitely.
We can't talk about the department generically.
Yes.
Okay.
And that will also, it will go to argument at the end of the day in respect of
the project,
of the project and what can still be done and
indeed
the relief.
Please proceed.
Well, yeah, just so to summarize, ma'am, what is.
So, in other words, what are the lessons learned, and how do we prevent this from recurring? I think that it would be very important for those that have been involved in the situation and those that continue taking care of mentally ill patients, because we wouldn't want a repeat, to actually use the situation as a case study and to look at the situation and examine the ethical failures along the line. Okay, because when you actually look at this tragedy, one can liken it to a moral pathology and an ethical crisis. And I think it's important to lay the facts on the table for healthcare professionals, for managers, administrators, etc., and get them to understand what went wrong and how to prevent the wrongs going further. I definitely think that there's got to be remedial action taken as well in terms of training in ethics and understanding ethics.
Thank you very much, Professor. Thank you, Justice.
Thank you. Advocate Mutamo.
Thank you, Justice. Good afternoon, Professor.
Good afternoon,
We
Councillor.
thank you for highlighting the issues that you have dealt with. We will pose no questions to you. Thank you.
Thank you.
Well, that's coming off lightly, Professor Dye. Re-examination.
I have no re-examination, Justice.
Okay. What remains of me is to thank you. And for agreeing to do this pro bono. I almost said pro amico and remembered that we're from the same institute and I can't say pro amico. But I would like to really thank you for being here and the views that you've expressed. Only a professor of ethics from a medical school will talk about moral pathology. It's an unusual combination, but it makes the point quite tellingly. Over time, obviously, there will be an award at the end of all this, and they'll be treated as expected to deal with equitable redress. And some of the valuable things you've said might very well become a component of that redress going forward. But again, we'd like to thank you. We have a practice here that at the end of the evidence of any and every witness, we allow them to have a valedictory statement before we excuse them. So it's your opportunity to do that.
Thank you, Justice. I think in closing, what I would want to say is I have done several ethical opinions previously, but doing this ethical opinion has really, really touched a raw part of the heart. It's also brought back the floods of memories pre-1994. You know, Steve Biko had said, and I want to quote, "In time we shall be in a position to bestow on South Africa the greatest possible gift, a more human face." When you look at the role players in the project, the question that you need to ask is, did they lack compassion? Did they not care? Where is this more human face? How far are we in terms of Steve's dream? And you know, Steve died for an idea that would live, and that idea that must live and must actually unfold is this more human face for all of us in South Africa. And we must be strong enough to ensure that this idea is not killed by those few who just don't care.
Prof. James Dye, we are thankful, and fortunately you are talking to the whole nation, so you are being listened to by many. But thank you again ever so much. And this is a valuable and value-adding part of the exercise that we are engaged in now. It must be added that the state is part of it. The province is a partner in seeking this healing. Sometimes I repeat it just again to find that balance all the time. And there can't be healing except if the department itself, probably a mental health care directorate, understands the extent of the devastation and the points that you have been making. But they're not challenging your evidence, so they are a good partner to try and resolve this matter.
Thank you.
And you are excused from where you are seated. Council, late in the day, and the last time I checked, it was a Friday. It's 10 to 5, isn't it? I'll start to my right this time. Anything, Council, that you want to say, record, or before we adjourn to Monday?
We have no matter to report at this stage.
Are we satisfied with the security arrangements for Monday?
Well, Justice, I'll have to check with the relevant officials. I cannot make the commitment now.
I'm not asking you to make any commitment. I think I'd like on Monday morning, we should meet at 9 o'clock so that I can be apprised of the arrangements. There's cause to believe that the numbers will be unusual, and there's cause to believe that, and I have a duty to make sure that at least the witnesses are well protected, and so too everybody else. So it's a matter that I would like you and staff in my office to talk about and to report on Monday morning before we start. Is that possible, Council?
We will do so, Justice.
Yes, let's meet at 9 o'clock, the latest on Monday, to talk about the arrangements. And will we be using this venue or another venue? Oba King? The larger venue. Very well. Anything else, Council?
Nothing more, Justice.
No. Advocate Groenewald?
We have nothing, Justice.
Get it done.
We have nothing to add, Justice Msanek.
Okay. Does Advocate Yina ever speak? I haven't heard her speak the last 2 days. You're okay, Council?
I'm okay, thanks, Justice.
Okay.
There's nothing from us, Justice.
There's nothing from both of you, is it? Okay. Or all three of you?
Justice, from our side, and I speak for both of us.
Yes.
We were informed that on Sunday we'll receive a transcription of the MEC's evidence or her interview with the Ombud, and I just want to make sure that that is still the case, that we will receive it on Sunday.
And the assurance was from which council?
I think it was from Gauteng, if I'm not mistaken. Oh, could I just take an instruction?
Gauteng has no right of audience, so that is his problem.
I see that that it now only will be available on Monday morning, Justice.
Yes, you'll have to do with that.
Yes.
And it is settled. Issues of leading of the MEC are all settled. Advocate
Yes, Justice Msanek, that has been settled.
Okay. Yeah. It looks like until the day is done. We have done what we have to do. In my young days as scout, I always remembered the oath. On my honor, I promised to do my best, my duty to God and my land, and so help me God. We should always do that. I think we've done that for the day. Shall we adjourn till Monday at 9:30?